Dear listener in the chair, it's me, Daniel J. Boland. This special episode of Ancel Glink's Quorum Forum podcast was recorded live at the Ancel Glink World Headquarters in Chicago, celebrating 100 Quorum Forum podcast episodes and our friend, Julie Tappendorf. Without further ado, Engineer Rick, roll it. The designated hour having arrived, I call to order this regular meeting of Ancel Glink's Quorum Forum podcast, the podcast local governments need to do business. On the agenda today, we celebrate a monumental milestone, our 100th episode. But first, let's take the roll. We have an equity partner at Ancel Glink. She is a prolific writer and counselor whose knowledge spans social media, land use, and countless other critical local government topics. She is joining us on the eve of her retirement to reflect on her distinguished local government law career, and we're going to ask her about it. Please welcome Quorum Forum Podcast All-Star, Julie Tappendorf. Welcome, Julie. Julie, looking back over your many years of service to local governments, all your professional accomplishments, all the legal victories, you'll probably most fondly remember listening to Ancel Glink's Quorum Forum Podcast. What would you say are your top 100 Quorum Forum podcast moments?
Oh, top 100? Each one of them, I guess?
Yes.
Except for this one because I haven't listened to it yet.
Ah.
I really enjoy the year-end wrap-up that talks about the new laws. I think our clients get a lot of benefit out of that, not just seeing them on Municipal Minute, but actually hearing our attorneys talk about kind of the practical side of what do you need to know for next year. So I would say those are my favorite.
Those are good ones, too. I enjoy the legislative update kind of mid-year, the same kind of what just passed and what's coming up, going to be effective at the end of the year. Good episodes, of course. Julie was a guest on our very first episode, and Ancel Glink's Quorum Forum podcast was inspired by Julie's long-running popular an award-winning blog, Municipal Minute, launched on September 3rd, 2011. Municipal Minute has registered more than 3.3 million visits and published over 2,400 posts, making it an essential resource for local government officials and staff across Illinois. There could not be a better way to celebrate episode 100 than by celebrating Julie's exceptional career. We also want to acknowledge the team that helped us reach this milestone, our regular co-hosts Aaron Monforti, Katie Nagy, and Tyler Smith, all of whom are joining us here today. Of course, our many guests, including regulars like Megan Mack, Greg Jones, David Silverman, Carrie Lynn Kraftheffer, Eugene Bolotnikoff, and the list goes on and on. Thank you all. And last but not least, the man who recorded and edited it all, the man behind the glass for our protection, Engineer Rick. Let's hear it for Rick. And of course, we're grateful for our listeners. We enjoy talking about new laws, cases, and local government topics, but it's even more rewarding when someone is actually listening. We are also joined by our live audience of Ancel Glink attorneys online and at the World Headquarters in Chicago. Give it up for yourselves. Later on, they will share some insights they learned from Julie over the years, along with their top 100 Quorum Forum podcast moments. We have a quorum. Dear listener, we are fortunate Julie is here to reflect on her career and share important lessons learned with our listeners. So let's get started. Julie, I think listeners would be interested to know, before your legal career, you served 8 years in the U.S. Army Military Intelligence branch as a Korean cryptologic-linguist. What is that?
So if I could tell you, I would, but I can't. It's a very top secret. We did actually have, my husband and I both were linguists. I was Korean in the Korean class, and he was in Chinese, so he learned Mandarin Chinese. And we did have top secret security clearances, and I seriously cannot tell you what we did day to day, but I can say that the Army trained us in language to become as fluent as you can become in about a year. All day long language, and then there were various jobs that the linguists did our job was to listen to transmissions and translate them. Others in my class, language class, did interrogation and some other jobs, but the details are very secret, even now, 30, 40 years later.
Oh, interesting. Very, very intriguing. How did your military service prepare you for your career, and are you spying on me right now?
Very much, and yes. So I think the military in general just gives you a lot of discipline. Being on time, and being on time means being 10 or 15 minutes early to everything. I actually heard that the other day when I was at a village board meeting. I got caught up in traffic, and then the parking lot was full, and they were doing a recognition of me, and I got there 2 minutes early, and they basically, it was, we were worried you were going to be late for the first time in 16 years when we're having this like recognition. But I think being on time and considering other people's time being valuable, and then I would say maybe just having a thick skin in government. I think that you had to in the military, and I think, being able to take criticism and not take it personally, I think is really important.
Oh, very interesting. So after law school, how did you decide to focus your practice on local government, litigation, land use? How did you get there?
Yeah, it really happened in law school. So when I went to law school, I knew I wanted to work for the government, but I thought it would be more on the side of being a prosecutor. That kind of interests me in the criminal side. But the first class that I really enjoyed was real property law. And Professor David Callies, who I know David Silverman knows really well, he was the professor, and I loved how he taught. I loved the class. I was fascinated with the land use side of things. I took every class that he taught, state and local government, land use, all of his writing courses. Also became his research assistant through the rest of law school, second and third year, and just got a lot of exposure to land use and local government. And David Callies had worked at Ross and Hardy's, which eventually became Burke, Bosselman and Weaver, which became Burke, Weaver and Prell, the first law firm that I practiced at. So I think working with him and really gave me a love for local government and land use.
Well, that's very, very interesting. What's something from that early in your career, that love from local government? How have you applied that throughout your career, maybe?
I guess I think about working for government as sort of a service more than it is a profession. Our legal career is a profession, but also just a service, because you're not just providing legal advice to the local government officials, and I have always preferred the government side, even in the land use, than the private side, because I feel like there's the important work we do for the community is part of that, what I see as a service-oriented profession.
So what brought you to Ancel Glink? What made you decide to come here?
So the reputation, Ancel Glink's reputation, as long as it's been around, which is almost 100 years. So someday soon, maybe in 5 years, I think, we'll be celebrating 100, not 100 episodes, but 100 years of Ancel Glink. But I mean, clearly the reputation as one of the premier local government law firms, if not having written the book, we always say, wrote the municipal handbook, but also Carrie Lynn Kraftheffer made me come. So you can ask her how she persuaded me, but yeah, she made me come here.
Yes, and you're all invited to the celebration of 100 years of Quorum Forum podcast when it happens. So I guess let's talk about one of your first loves, land use. You co-authored Bargaining for Development in 2003, Development by Agreements, another book you authored. What drew you to land use, and specifically your interest in the importance of development and annexation agreements for communities? Yeah,
so much of development can feel very adversarial and controversial. You get a development coming in, and it's rare that everybody in the community and on the board and the plan commissions are 100% in favor of whatever development it is. And so sometimes for both the developer and the government, it starts out adversarial. What can we get out of this, or how do we reject this development, make this developer go away. And annexation and development agreements kind of take that adversarial role out because they're contracts. And so the point is that, yes, we as the developer want to do this development in your community. We understand that there are impacts. How can we come to an agreement to maybe mitigate those impacts that don't make the development not work because of the financial side of things? And also just in Illinois, from a legal perspective, home rule, and we always say this, I learned this when I was probably a first or second year associate. Home rule can do anything. Like, if you're a home rule municipality, just do it. But for non-home rule municipalities, they have to follow a lot of the statutes on procedures and the limitations on impact fees and some of the other exactions and incentives that they can do. And especially through an annexation agreement, just opens up a lot more possibilities for the municipality, more control, more authority to impose, conditions that they might not be able to do from a zoning perspective. And then for the developer, I think it's getting some assurance that the municipality isn't going to pass an ordinance and then just revoke it a couple of years later, because it's an agreement and they have a contractual right for it to continue. So I like using them. I think it's a good way for municipalities to get that level of control and assurances that they get what they need.
I'm thinking about just how that's changed over the years from when I started here, which was the same time you started here. But in 2008, a great time to start the practice of law, by the way. And a great time to start at Ancel Glink, by the way.
Yeah.
The interesting time. The Great Recession through today, I'm sure the changes in the practice and application of development agreements has changed. What are some of the most important things that municipalities should know when they're considering a development agreement?
Yeah, so first is authority. I mean, the annexation statute in Illinois does give express authority to enter into annexation agreements, but there's a certain process to follow. So you have to be careful to make sure you follow that, the notice, the hearing, all of that. Development agreements are a little different, and there's always a debate in local government with local government lawyers on, can non-home rule municipalities enter into development agreements outside of the annexation. And even at our firm, and I know that the same arguments happened at my former firm, there are differences of opinions on the authority. But I think it's there. I think that when you tie it to maybe conditional uses or planned developments, there's authority to do that. And then you just want to make sure that you document everything that you want. We represent municipalities for the most part, that the municipality wants to make sure happens. And you mentioned 2008. Pre-2007, there was massive amounts of development happening, especially out in the west and northwest suburbs. When the recession hit, those didn't develop. And so there's a lot of development and annexation agreements still out there.
Yeah.
And so as you're thinking about potentially the next recession, building into those agreements provisions for security and increasing performance security, because costs only go up. One of our communities is developing a 1,000 lot, it's actually 1,100 lot subdivision based on a 2006 annexation agreement, which is about to expire.
Right.
Another thing to consider.
Right.
And that development is still moving forward, and there were a lot of concessions that had to be made to make it work. So being flexible, I think, is important.
Yeah, we've got the eye on some agreements that we are hoping to come off the books very soon.
Right.
In some communities. Important part of development agreements, or even outside of the development agreement context, are land use approvals. What are kind of some of the most common mistakes you might see a community might make when considering land use approvals?
So the first thing I would say is involving your attorney too late. So after you've gone through the review, the staff review of the application, and you've heard all the public comments and you've received all of those, and you've scheduled the public hearing, and you hold the public hearing, and then it starts to look like it's going down, potentially challenged. Maybe it was rejected, through the public hearing process, or maybe it was approved and the neighbors are all mad about it. And then all of a sudden the call to the attorney of, oops, we might have messed up at the public hearing because we didn't allow people to cross-examine, or we cut people off, or whatever it was. So I think it's important for our clients to remember it's a lot less work and cost, for that matter, to avoid litigation by having your attorney involved earlier. And not for everything. Some things are very routine, but for those, when you see that something's going to become maybe objectionable, you're going to have some opposition to that, having the attorney at the Plan Commission, Zoning Board hearings and advising, I think, is important.
Getting them involved early, having a plan, communicating with the public and the applicants, that's all good advice. What are some of your most important tips for helping with a controversial land use application? And are you available to cover a meeting on Monday for me?
No, I actually have a meeting on Monday night, but I had a planned commission meeting last night on a very controversial packed room kind of development. And I think our role is not to take a side on a particular application or development. We are neutral. We don't vote. We don't have an opinion on whether a particular development is right for the community. We shouldn't. We look at it from, is the process legal? We want to make sure that due process rights of the developer or applicant, due process rights of the residents who may be in favor but more likely are opposed if they're coming out, that we're advising on procedural issues. We are anticipating potential legal questions. One thing I always ask, and I did this yesterday, if the municipality doesn't post public comments on the website or provide them in advance, I reach out to the planner, the director of community development, and say, have you gotten any public comments? And I think reading those and preparing for the meeting, and you can anticipate that person's going to get up at the meeting like they did last night and raise concerns, and sometimes legal ones. And we need time to be able to look at that. And when I say time, this was 4:00 and the hearing's at 7, but that's better than getting, getting the information during the public testimony period. So I think being well prepared and anticipating is really important.
Yeah, soliciting and reviewing their comments in advance is good, not to mention sharing those public comment rules and the hearing rules and whatever other rules with the public and the applicants in advance can surely help a hearing go more smoothly as well. So land use litigation, another important part of your practice. How has that informed your day-to-day work with your clients?
So when I started as a brand new attorney, in my mind, the last thing I wanted to do was litigation. Like, that was not of interest to me. I really liked the transactional side of land use, taking an application, watching it go through, assisting the municipality, going to the Plan Commission hearings, all of that. It was all, that was what was interesting. When the recession hit, there were not little to no land use applications coming in. And my practice at that time was focused almost exclusively on land use back in 2006. I mean, at that time, I was crazy busy going to Plan Commission meetings that were going until 1 a.m. because there were so many applications. And that dried up. And then what happened is people started suing. Developers started suing. Municipalities were trying to go after developers. Developers were going into bankruptcy. So the practice shifted at that time. And so while I didn't think I would be involved in litigation, it was kind of a natural fit to have the land use background and then, do the land use defense. So on the municipal side. And so much of that those of you that do land use litigation, it kind of boils down to procedural or substantive due process.
Yep.
And that's why I say involving the attorney early at the hearing process, that's our job, is to make sure that the commissions are looking at the standards. That's the substantive due process side. Those of you that do land use, you know, LaSalle factors. What are they considering? Making sure that they're going through and that they make decisions based on those standards. But even more important, because most of the lawsuits, land use litigation that I've been involved in, is procedural due process. And the courts are very careful about not dismissing cases that raise issues of notice, or the public didn't have an opportunity to speak, or you cut them off, whatever that is, making sure that the due process rights of the applicant and the members of the public are met.
Yeah. So, what are some of the keys to defending a local land use decision in court then?
Yeah. So the first thing, obviously, you read the complaint and see what the claims are. So most of the land use cases have multiple claims. They're usually brought in state court. We've had some federal, if it has a federal question, like religious land use or First Amendment component. But most of them are in the circuit court, and most of them are both substantive, that the municipality either denied or approved it without really applying the standards for whatever zoning was requested, and then procedural, that there was a mix-up in the notice. So it wasn't published properly, or it wasn't clear enough, or people didn't get the notice, or that the hearing, I had one case where the hearing was held during the pandemic, and so it was held remotely, and somebody argued you can't hold a land use hearing, a plan commission hearing, remotely, which of course we all know we could at that time.
Right.
So it's carefully analyzing the claims and then, you know, taking a look at how best to defend those based on, you know, other cases we've handled, making sure we're talking to the client about what happened at the hearing. If we weren't involved, hopefully we were. Makes it a lot easier if we have somebody in the office that's been, you know, involved in that from the beginning.
Well said. Let's talk a bit about the blog. Your very first post on Municipal Minute in 2011 was titled "Tweeting into Trouble," which today would be x.com post into trouble, or whatever.
Threads.
So what made you realize that social media was going to be an important topic for local governments?
Yeah, so there wasn't anyone out there at the time really looking at the legal issues of social media, and very few of our clients were using social media in 2011. But I think what interested me and what got me involved and forced me to take a look at the issue was one of our clients who I've represented since 2008. The village clerk was very active on Facebook, and she really wanted to set up a village Facebook page. And I remember her calling me and saying, you know, I know the technical side, I know how to set it up, but I just wanted to check, are there any legal issues? I'm like, that's a great question. I don't know, because there weren't cases, there weren't any statutes, and there really wasn't anything out there. So I had to think through and analyze, okay, what could possibly be legal issues with a government entity setting up what could potentially be a public forum. And so what I advised her is, don't open up the comments. And those of you that are on Facebook know you cannot turn that off anymore. But in 2011, you could.
Yep.
And I said, you know what? Don't open a public forum. Use it to just talk to constituents for now, because we don't know the legal landscape of, if people are posting comments, what does that mean? And she's like, oh, no, it's fine. This community is super nice. Everyone's awesome. Everyone's going to post really nice things, you know, famous last words. And so she set it up, opened up comments, and there was some comment posted maybe a couple of months after the Facebook page was created that called the mayor some, you know, big stupid something or another. I don't remember the exact thing, and the mayor called the clerk and said, take it down. You know, take that post down and delete it. And she called me and she said, well, I remember you saying that there might be a problem. And I said, well, you know, there's no court cases on this, but it's interactive. And so you probably opened a public forum when you said, please comment, kind of like at a city council meeting. And so I told her, don't delete it. And if the mayor's mad, have the mayor call me. And then I realized this isn't going to be the only client that's going to need this kind of information. And there was nothing out there. And so I talked to Patty Salkin, who is a planner friend of mine, who's written a lot of books and lectures. She's a dean now in law school. And she and I were talking about it, and I said, we should look into this and write a book. And so we did. We pitched it to the ABA. There was nothing out there. And the first social media and local government book came out in 2013. I think we wrote it in 2012. And it was basically, we have no idea. There's no cases, there's no law, we don't know. But here's what we think.
Right.
We think it's going to be a First Amendment issue. We think that governments can't just delete comments that they don't like. Because we think, and that, of course, is now we know where it went.
Right. So you've followed this issue for many years and finally made its way all the way up to the U.S. Supreme Court. The recent Linke v. Fried ruling said public officials' social media activity, like blocking users or deleting comments, is only considered state action that potentially infringes upon a person's First Amendment rights if the official had actual authority to speak on behalf of the government. So could a local government just say, I'm adopting a policy that says you don't have authority to speak for me and your posts are not government activity?
So I think they could do that. How enforceable it would be is hard to say. The Supreme Court has come out in multiple cases. First, that a government social media account is a public forum. We know that. It's not traditional, but it's either limited or designated. And from a legal perspective, that means that you can't discriminate based on message. So you can't delete a comment because you don't like what it says. And usually that's why our clients delete them or think about deleting it, is because it's critical speech. And criticizing the government is one of our highest protections. On the personal side, some of our clients are public officials, and employees have set up their own social media sites, but then they use them for government business. And
right.
that was the most recent Linke case from last year,
right.
where the Supreme Court said, okay, we know what the rule is if it's a government site.
Yep.
Does that rule apply to a government official or employee's personal site if they use it for government purposes? And that's where the actual authority came out, that if you have authority to speak, and it has to be more than just you think you do, but that there's some ordinance or policy or statute or something, and then you exercise it, that exercise is subject to the First Amendment. Could a government say, you don't have authority,
right?
And that would take away from the actual authority? I think that could be true of certain public officials and employees, but you can't take away, let's say, a mayor's authority to issue executive orders, because that's statutory. So to say, okay, for purposes of social media, you don't have that authority, I think it's case by case, but it's an interesting way to look at it.
So why, after this decision, is it still important for local government staff and elected officials to consider maintaining separate personal and professional social media accounts?
So I've always advised that. I think it's a good practice, putting aside the legal. If you're a mayor in a small community and you have your personal social media page, and you are doing what all of us do on our personal pages, posting vacation pictures and, weddings and graduations and for me, pictures of my dog, because that's what my, my whole Facebook is about Ruby. I wouldn't want our clients to have all of that, and then, the occasional government post comes in, and then there's all this criticism of that. And your aunts and your high school friends and all of that, they don't need to see that. And so from a practical, it's just better to have it. But from a legal, based on the U.S. Supreme Court's decision, if you did post, if you were the mayor and you posted about an executive order on your personal page, those comments would need to stay. And deleting them, because I could delete all the comments. If somebody said my dog was ugly, first I would block them and never talk to them again because she's very cute. But I can just delete it.
Right.
But if you are a government official and you post about, let's say you're an HR director and you post about a job opening on your personal page, you have the authority to recruit. You have the actual authority to go out there and speak about that. And what if people post terrible comments about, I wouldn't work for that community, it's terrible, whatever.
Right.
Now you have to leave it and it's on your personal page. So I think it's a good practice. I think it may be too late for some of our clients. So then they just have to be careful.
Yeah, it's hard. You also authored chapters on compliance with open records and meetings laws for Municipal Law Desk Book and the Illinois Institute for Continuing Legal Education. What are some of your favorite tips for an effective meeting?
I would say where things sometimes go off the rails is during public comment. So if you're like a public body and you don't yet have public comment rules, make sure you adopt them. Mm-hmm. You cannot impose any restriction, time limit or otherwise, unless you have rules in place, written rules that you've adopted. So having rules, but then even more important than that, and I've advised this to every one of my clients, public comment is comment. It's not question and answer. It's not an interrogation. It's not it's not meant to be interactive. And the Attorney General's issued plenty of opinions stating that you do not have to answer questions. You do not have to engage with the public in that forum. There's plenty of other places to talk to people. So to me, the most effective meeting is where the chair of the meeting will open up the public comment, explain, yes, you each get 3 minutes. We are going to time you. We're going to give you maybe a warning, and we are going to cut you off because everybody needs an opportunity to speak. And also, we are not going to answer questions. This is comment. Mm-hmm. Staff can get back to you if you want to share your information. We will get back to you because we care about what you say, but we're not going to engage. The worst thing that can happen is during public comment, somebody comes up and asks a bunch of questions of the public works director that are coming out of left field, and the director's like, I need to research these. Right. And it's not productive at the meeting, and it's also not good for your staff to put them on the spot. It's better to have a more thorough answer. So instead of saying, hey, Director so-and-so, can you answer these? Say, why don't you reach out to the director who will get back to you and meet with you and go over these?
Good advice. And speaking of public comment, this is a regular meeting and we have to have public comment. So today we're opening the floor to our live audience of Ancel Glink attorneys. We're inviting you to share one key piece of legal wisdom or professional lesson that you learned from Julie over the years that our listeners, elected officials, and local government staff
Thank you, Dan. Pleasure to be here for the 100th episode.
Own work. You may also share
so I
an
just want to
unabridged
first
list
off
of your top 100
say that I'm really grateful to have worked with Julie at Ancel Glink.
Who wants to go
Collaborating with
first?
Julie has shown me the value of composure and consistency
Katie Nagy's
in our
here.
profession.
Katie.
Julie tackles every challenge with
you,
a
Dan.
clear mind
Pleasure to be
and
here for the
always
100th episode.
keeps in mind the bigger picture. So I just want to
Julie's
first
always
off
respectful of others'
say
times
that I'm
and
really
is
grateful to
consistently
have worked with Julie at
responsive,
Ancel
which is
Glink.
not something all
Collaborating
attorneys
with Julie
are.
has shown me the
So
value
much so
of
that it's
composure
easy
and
to forget how
consistency
busy Julie
in our
is
profession
because she never
Julie
shows any
tackles every
stress
challenge
from
with
juggling
a
a
clear
multitude
mind
of clients.
and always
Julie
keeps in
also
mind the bigger
exemplifies
picture.
the
importance of
Julie's
lifelong
always
learning
respectful of
and staying
others'
current
times
in the
and is
legal
consistently
profession.
responsive,
A lesson
which
made
is not
clear by her
something all
creation
attorneys
of
are, and dedication
so much
to
so
municipal
that
minutes.
it's easy to forget
And
how busy Julie
another
is.
lesson that I
because she
still
never
need to
shows
work
any
on
stress
is that you don't
from
always
juggling
have
a
to use
multitude of
shall.
clients.
Sometimes
Julie also exemplifies the importance of lifelong learning and staying current in the
keep it
legal
in the back of my
profession.
mind. So
A lesson
Julie,
made
thank
clear
you,
by
and
her
I wish
creation
you all the
of
best and dedication to
Julie,
municipal
your
minute.
rebuttal.
And another lesson that I still need to work on is that you don't always have to use
I'll go
shall.
first, and
Sometimes
there are incalculable lessons I've learned from Julie, but before I delve into some of the few things I've learned
I
from
do
her,
keep it in the back of my mind.
my first blog
So
post
Julie,
for the
thank you,
Municipal
and I
Minute
wish you all the
pertained
best.
to a prevailing wage case.
Julie,
And
your rebuttal.
when I wrote up submitted to Julie,
No
she
rebuttal.
eviscerated my first
Who's
draft.
next?
And
Gene,
Dirk was
I'll go
copied
first.
on the email
there are
correspondence, and
incalculable
he's like,
lessons
take
I've
it
learned
easy,
from
he'll do
Julie,
better
but
next. Before I delve into some of the few things I've learned
subsequently
from that moment, I've
my
learned
first
to write
blog post
for the
a
municipal
lot better,
minute
and I
pertain to
credit
a
Julie
prevailing
for that.
wage case. And
some of the things
when
I
I
wrote
wrote
up
up
from her
submitted
is
to
when I
Julie,
shadowed her at a meeting one
she
time.
eviscerated
said
my
that
first
we don't make
draft.
policy, we advise the
And
policy.
Dirk was copied on the
I think that's
email
powerful because
correspondence, and he's like,
we each might
take
have
it
our
easy, he'll
individual
do better
opinions
next.
about laws or what they should be,
So
but we're not elected or
subsequently, from
appointed.
that moment,
They're the
I've
ones that
learned
make
to
the
write
decisions, and
a lot better.
within
and
the bounds of legality,
I credit Julie for
it's our
that.
job to help them make those
Some of the
decisions.
things I've learned from her is when I shadowed her at a
Well
meeting
said,
one time,
Eugene.
she
Who's
said
next?
that we don't
Anybody
make
else?
policy, we advise the policymakers.
Airman
And
40.
I think that's powerful because
So first,
we each
I
might
just
have
want to
our
thank Julie
individual
for
opinions about
the
laws
immense
or what they
impact
should
her
be,
work has
but
had on
we're
Ancel
not elected
Glink
or appointed.
and the
They're the
field
ones
of
that make
local
the
government
decisions,
law.
and
You've been a
within the
fantastic
bounds of
mentor and
legality,
role model
it's
to
our
me and
job
so
to help
many
them
others.
make those decisions.
The key insight I want to share is pretty
Well
general,
said,
but I think
Eugene.
it's
Who's
really
next?
important.
Anybody
And
else?
if we don't remind ourselves of it,
Airman
it's easy to get
40.
lost in the shuffle.
So first, I just want to thank
So
Julie
legal
for
issues don't
the immense impact
happen
her
or
work has
arise
had
in
on
a
Ancel Glink.
vacuum, and
And
people
the field
working
of
in local government
law,
should be aware
you've been a
of the
fantastic
knock-on
mentor
effects
and role
of
model to
policy
me and so many
decisions, legal
others.
decisions. So
The key insight
I
want
think
to
working
share is
with you
pretty
on so
general,
many
but I
First
think it's
Amendment
really
issues
important.
has,
And if
given
we
us
don't remind
plenty of
ourselves of
opportunity
it,
to
it's easy to
evaluate
get lost.
that. So
In the
it's not very
shuffle.
hard for us to like
So
make a
legal
diagram
issues
or
don't
keep notes
happen
on
or arise
types
in a
of
vacuum,
speech
and people
regulations
working in
that
local
may be
government
imposed
should be
in
aware
different
of the
forums.
knock-on
You and
effects
Dan
of
talked about
policy
the
decisions,
Linky
legal
analysis,
decisions.
traditional
So
forums,
I
designated
think working
and
with you
limited.
on so many First
But
Amendment
when the
issues
rubber
has,
meets the road,
given us
plenty
plenty
of
of
opportunity
opportunities
to
to
evaluate
an
that. So
understanding of
no, it's not
the
very hard
impact
for
on
us to like
staff
make a
and other
diagram or
people.
keep
So
notes
we've done so
on
many
types of
presentations together and
speech
separately on
regulations that may
First
be
Amendment
imposed in
audits
different
and
forums. We,
while
you and Dan
filming
talked
public
about
employees and
the
their
Linky analysis
workspace during the
during the
workdays
forums,
legal,
designated and limited.
it doesn't make it comfortable.
But when the rubber meets the road,
that knowledge needs to be coupled with an understanding
and I think the
of
opportunity
the impact
to
on
couple
staff
legal
and other
advice with
people.
staff
So
training,
we've done so many presentations together and
de-escalation,
separately on
practical solutions
First Amendment
is
audits
really important.
and
While
because if
filming
our
public
advice
employees in
isn't
their
doesn't have
workspace during the workdays
practical,
legal,
an understanding
it
of what
doesn't make it
staff are going
comfortable.
through or what
Staff get
patrons are going through, then
patrons
it has no
uncomfortable being
value.
filmed.
And so
And I think the opportunity to
just
couple
thinking about
legal
how Julie's
advice
been a
with
wonderful
staff
resource on
training,
First Amendment issues,
de-escalation, practical
I'll take that into my
solutions is
career
really
going
important.
forward. And
Because
for
if our
advice
listeners
isn't,
doesn't
think
have
twice before
practical,
you, an
delete
understanding
that
of what
comment
staff are
before you
going
shut
through
down
or what
an audit,
patrons are going
before
through,
you deny
then
a permit
it
application
has no
for
value.
protest.
And so
I think,
and
you're the conduit
just thinking
for
about how
government
Julie's been a wonderful resource on
matters,
First Amendment
when it comes to
issues,
speech,
you're the speaker for
I'll
the
take that
government,
into
and
my
that's
career
kind of a
going
powerful
forward.
and important
And
role
for our
and I will
listeners,
take Dan up
on my
think
favorite
twice
quorum
before
forum
you
member.
delete that comment
So
before you shut down an audit.
last year I
Before you
hosted an
deny a
episode
permit
with
application
Dirk
for a
Price and Maj
protest.
Sharma
On
and you're the conduit for government,
and it's one of my favorite episodes
matters.
for content.
When
but
it comes to
also,
speech,
I'm so
you're
grateful
the
to
speaker
Dan
for
and
the
Rick
government,
for
and
not
that's kind of a
cutting
powerful
nearly
and important
25
role.
minute.
And I
intro,
will take Dan up on my favorite
section
quorum
where we
forum
talked
memory.
about Star Wars exclusively.
So thank you for that. Last year I
Dirk's
hosted an
incredible.
episode with Dirk
His
Price and Maj
voluminous knowledge of Star
Sharma
Wars.
on
do a whole
contracts and
podcast
immunity.
Oh,
And it's one of my favorite episodes for the content.
take
But
you up
also,
on it.
I'm
We'll
so
do it.
grateful to
Oh,
Dan and Rick
I like
for
it.
not cutting the nearly
Anybody
25
else for
minute
public comment in the room
intro
online? Anybody?
section where we talked about Star Wars
Kurt
exclusively.
Asper.
So thank you for that.
This was an impossible task, trying to come up with
voluminous
like
knowledge
the
of
most
Star
We do a
Wars.
whole
impactful thing I've
Oh,
learned
we
from
could-
Julie.
we could
because
do a
I've
whole
been working with
spin-off
her for
podcast.
I'll take
9.5 years.
We'll
I feel
do
like
it.
I talk to her every other
I
day.
like it. Anybody
been a
else for
mentor
public comment in the
beyond
room
words I can ever
online?
describe
Anybody?
that. So trying to pick one thing was
Kurt
impossible.
Asper.
So especially one legal. This was an impossible task trying to come up. So to just kind of echo, like, besides the most impactful thing I've learned. I will say every time I draft and read, every time I draft 9.5 years, Julie's in the back of my mind. Not shall, it's will. Been a mentor beyond. But to kind of echo Aaron, it's really just more of the approach. Trying to pick one thing how we work as local government lawyers, especially how we give advice. So when you get out of law school, it's I'm going to write a 5-page memo versus I'm going to use Latin terms. Every time I cite everything, I'm going to use every case. Julie's in the back of my mind, not Julie taught me like the clients aren't going to understand that. But to kind kind of echo Aaron. It's clients are going to go look up that case citation and read it in that memo. You know, they don't want 6 pages of statutory. When you get out of law school, it's I'm going to write a 5-page memo. Them I'm going to use Latin terms. How do you I'm going to cite everything. I'm going to interpret the law, every case, and advise them on how to achieve their goals. That's Julie taught me, like, the clients aren't going to understand my whole perspective on how clients are going to go look up that case citation and read it in that memo. they don't want 6 pages of statutory text. Privileged to work with her for all how do you help them solve their problem?
Kurt.
How do you
David
use the law,
Silverman.
interpret the law, and advise them on how to achieve their goals? And that's really
since 2000.
now like my whole perspective.
There was a
on
brief
how I
interruption of
practice
time when
the
she
law.
stated
And I
how
learned
night
it
and I
from
had come
her. So I
here.
think that's
But
my
almost
biggest
from the
takeaway
first
from
time I met Julie,
being privileged to work with her
all
for
those
this
years
time.
ago,
Very nice, Kurt.
I
David
found her
Silverman.
to be perhaps the best attorney
I've
I've ever
practiced local government law with Julie
and that
since
has not
2000.
changed. We don't do as much work as
There
we
was a
used
brief
to,
interruption of time when
but
she
I do
stated
know
how
that if I
night and
ever
had come
had
here,
an issue that I
but
wasn't quite
almost
sure how
from
to
the
deal
first
with,
time I met Julie,
Julie would be the first person.
all
I
those
go
years
to.
ago.
And I say that with the knowledge
I found
that
her to
Stuart
be
Diamond,
a luminary,
perhaps
of
the
course,
best
in our
attorney
field,
I've ever worked, is also a member of our firm,
and that has not changed.
But I, over
we don't do as much
period of
work as
time,
we
have
used to.
developed a long working
But I do
relationship
know
with
that if I
Julie
ever
where I could
had
have a
an
conversation
issue
with
that I
her,
wasn't quite
perhaps
sure
on
how
a
to
level
deal with,
that I could not.
Julie
have
would
with
be the
someone like
first
Stuart.
person I go to.
So I'm going to miss. And I say that with the knowledge that
I'm
Stuart
very happy
Diamond,
you've made the
a luminary,
decisions
of
you've
course,
made
in
for
our
the reasons
field,
you've made.
is also a member of our firm. You've definitely
But I,
enriched my
over a long
practice
period of
by
time,
being a member
have
of
developed a
being
long
part of my
working
practice,
relationship with Julie,
practicing
where I
together.
could
So
have a
thank you for
conversation with her, perhaps on a level that I could not have.
Anyone
with
else
someone
in the
like
room
Stuart.
or online?
So
I
I'm
think
going to
there
miss
were
you.
a lot of very
I'm
kind
very happy
comments
you've made the
in there.
decisions you've made for the reasons you've made.
I think
But,
for me, some of the themes
you've
that I
definitely
picked
enriched
up
my
on, like
practice by being
the
part of
responsiveness,
my
Julie's always
practice,
impressive,
practicing together. So thank you.
responsive to anyone, attorneys,
Anyone else in the room or
clients
online?
alike. I think
there
that's
were
a lot of very kind comments in there for attorneys and local government staff. For me, some of the themes that I picked up on, information with elected officials at the right time. Always impressive. That is responsive to something to strive for. Attorneys, clients alike, email inbox. I think that's an important lesson. Explode. Well, thank you all for those for attorneys and local government staff who were in the information podcast sharing information with elected officials at the right time.
Yeah.
You have that is.
Oh, we got Steve Mart. Steve Mart
something
online.
to strive
you got.
for,
What are your top
even as,
100
your email
podcast
inbox
moments?
just let's hear explodes. Well, thank you all for those. So many top forum podcast moments.
Well, I would concur with everything that's been stated about Julie.
we got Steve Mart.
She is certainly the gold standard in
you got. What are your
municipal
top 100
practice, and
forum podcast moments?
that's not only true, among our firm or in our firm, but also downstate. She's well, I would concur with everything that's been stated about Julie. I would say, Dan, the best. She is certainly the gold standard in the municipal episode about the Sandhill Cranes. That's not that you had. The Nebraska not only true, with among our firm that was in our firm, but also downstate. I hope you can follow it up. Well respected, perhaps with another episode. I would say, Dan, the best quorum forum had to be the episode about the Sandhill Cranes that you had, the Nebraska Sandhill Cranes. That was a tremendous episode, and I hope you can follow it up, perhaps with another episode.
Steve, that one did numbers. I'll tell you. Your knowledge about Sandhill Cranes almost matches Dirk's knowledge about Star Wars, for sure. And any other public comments, online or otherwise? Seeing none, I do want to get a few final thoughts from Julie here. What was mentioned during our public comment section many times, but the blog, like what made you want to start the blog, and how has that been helpful to clients across and elected officials and staff across this great state of ours?
So I've always liked to write. I always wanted to write books and chapters, and I've written quite a few legal publications, articles, chapters, books, all of that. But when you do that, it's like a very specific focus, and it's a lot of work at one time, and then you're done. And I really thought it would be, I guess, more helpful for me to keep current with the law if I was looking at it every day, thinking about whatever new cases are coming out, or bills or statutes, or, PAC opinions. When that started, I think that was 2010, that the PAC started issuing opinions. And so it's just part of my love for writing, and I do love to research as well. So, looking up the cases. I hear a lot from people that when they're looking for an issue, and I hear this from competitors, and Carrie Lynn would say, why are all your competitors like following your blog? And they say, when I'm researching something for a client, that's often the first place I go. Like, is there a case on this? And they'll go to Municipal Minute and see. Not that we're trying to do work for our competitors, but I assume that there are attorneys here that do that, because I do.
Yeah.
I don't remember every post I wrote over the last 14 years. So sometimes it'll be like, there was an annexation agreement case. I don't know if I wrote it up, but I probably did. Let me see if I can find it. And so I think it's helpful. And then for clients, I think, and this was something that Eugene raised, that I've always felt it's really important to write for your audience.
Yeah.
And that is not, we're not writing, the blog is not being written for judges. It's not being written for, some scholarly law review article. The intended audience is our clients or potential clients. And so it needs to be reader friendly. I don't want to see summary judgment and motion to dismiss, because they don't care. What they care about is there was an interesting case about a First Amendment issue or a civil rights issue, and what did the court do? And why did they do it? And not into procedural. And so if you write a blog post for me and then you're like, that's what I'm doing. I'm taking out all of that, because we need to think about what our clients are needing out of our legal advice. And I think that the blog has been good for them and giving them some timely information about developments, but also in a platform and in a way that they can easily understand it.
Hey, and that's been an inspiration to the podcast too, talking about local government law in a way that regular people and can enjoy and understand, and that's been an inspiration to us and from on the podcast side of things. And so if looking ahead, Tweeting into Trouble was your first blog post. What's the next one? What's the next Tweeting into Trouble moment coming for local government law and lawyers and staff? Is it AI? Is it something else? What is it going to be?
I think AI. I think that we're just at the start of some of the legal issues. I think that it can be really helpful. But Aaron and I have done enough research on AI and the potential copyright issues, the hallucinations, which are very frequent, and not just on the base ChatGPT. I mean, even in the pay AI programs, there's still hallucinations. We've all read stories, too many, frankly, of attorneys that are submitting briefs to the court, and they're not even looking to see if the cases are real. And that's something, any of you that have worked with me in litigation, that as soon as we get a complaint, or usually it's like a response to our motion to dismiss, what's the first thing I do? Pull the cases. Every single case cited by the other side, I pull. And if they don't exist, you can bet we're going to bring that to the attention of the court. And we don't want that to be us. And so I think from a local government law, we have to be very careful. We cannot trust the output without verifying. And then for our clients, I think about using one of the AI programs, let's say, to moderate your social media page.
Yeah.
AI thinks, if you ask AI, is hate speech protected by the First Amendment, it says no, which we know is wrong. If you ask ChatGPT, what are the types of comments that I can delete, it will say criticism of the government, hate speech. I mean, all the things that we know are protected. And so we can't rely on that. And so we need to advise our clients to be very careful. The other thing, and this is a good example, I had a client who sent me, thank goodness, a copy of a draft social media policy that they had put together for their public body. Hey, can you just take a look at this? And right away I see that it's unconstitutional. And so I reached out and I said, did you get this from another public body? Because I was hoping it wasn't one of like our other clients that had, and oh no, I just plugged it into ChatGPT and this is what it came out with. Thank goodness that we're getting reviewed, but how many of our clients might be just using it for legal reasons without understanding. Because if you don't know, if you're not a lawyer, you don't practice in that area, you just sort of accept it. So yes, I think AI is going to be a big legal issue moving forward.
And it's baked into everything. The AI summaries of the local government meeting videos, the other generative AI records that you're creating. Are you creating public records? What do you got to do with them? How do you treat them? I think there's any number of issues. What other issues do you foresee coming up with AI, do you think?
Confidentiality. So anything you input into ChatGPT is not confidential. So if you're inputting information from lawyers, attorney-client communications, and from our clients, maybe information about employees and personnel issues and medical information, everything goes in and then it's used to train, and the generative AI is learning from all of that. And so there's nothing confidential. So I think that's another issue. I had somebody, a client say, we were going to hire a consultant to come up with a new brand, but we don't want to spend the money, so we're just going to use ChatGPT. Well, guess what? If you do that, it's using copyrighted material from others. So it could be using something that somebody else has a copyright to, and then you're going to get that challenge where if you hire a vendor and you get it in the contract that they have to confirm that it's not copyright, then you have some protection. So I think we just have to be careful. It has a place.
Yep.
I'm not the crabby old, get off my lawn about it. I mean, it was like social media. I thought it was great for our clients. And AI can be very good, but I think we just have to, we have to advise to be cautious.
What other advice do you have for the next generation of municipal attorneys and staff and elected officials out there?
So I think for attorneys, I would say, I think responsiveness is probably one of the most important things that we can give that doesn't cost anything, and we don't have to research for it, and we don't have to, but to respond. For me, it's responding same day. And that doesn't mean always the substantive answer, but on it, taking a look at that. I'll get back to you later this week. Clients appreciate that. I hear that all the time. All of my clients that have talked about, oh, you're retiring, we're going to miss that. And then I also think what's really important, and it was mentioned a little bit, is when you're assigned something by a client, if a client's asking you to do something, you need to always remember what they asked, and that's the answer, right? It is, don't get caught in sort of this what you think they need and but really look at, and I do this before I respond. If they send an email with 5 questions, we want to respond to all 5 of the questions, but also thinking about what did they ask and what do they need. So we don't want to be yes people. We want to say yes, but if we need to say no, we should. It should be pretty rare. But always think, where does the client want to go and how do we get them there? I'm always thinking about that when the client raises something and they want something. And then for local governments, I think, use your attorneys. It can be significantly cheaper, and we always think about cost, but to get the attorneys involved early, because litigation is very expensive, and having that advice up front, I think, is really important.
You have grand plans to someday write a best-selling legal thriller. Which people in this room will be characters in your book and why? Well,
first, it's kind of top secret, but there is a character called Jan Dolan. So in case anyone is wondering, there will be a Jan Dolan. So I'm not going to tell you anything about the plot.
The victim, okay. Well, what else are you excited to spend your newfound time doing? Covering meetings?
Monday Night Football, although there won't be much left, but I have, in my entire career pretty much, I have had meetings every Monday night. Always have meetings on Monday nights. And I am a football fanatic, and I miss Monday Night Football. And getting sleep. I think about, last night, late night meeting, lots of late night meetings, and maybe just because I'm an early riser, getting more sleep, and then just hanging out with my family and my puppy. who is really cute.
And the blog staying up?
Yep, I'm still going to write the blog.
Do I need to print it out before?
No, it's still going to be there. I that was one thing that I said. I'm not going to be doing night meetings anymore. I'll be available for some for some transition help, and I am going to continue writing the blog because I'd like to write.
No, and we like to read it, and we appreciate you for your valuable insights and want to congratulate you on your distinguished career. It's an honor to celebrate this landmark 100th episode with you. Let's hear it for Julie Tappendorf, everybody.
And by the way, thank you, Dan, because the podcast is amazing. And I always hear from people, like, we love it. Some people like to read, so they're following, and some people like to listen. And so I think it's great that we're able to give our listeners and readers a little of both.
No, appreciate it. You've been a true inspiration to us. We want to extend our thanks again once more to engineer Rick Perez, our co-hosts, guests, listeners, for helping us reach this remarkable 100-episode milestone. Before we go, we want to remind everyone to subscribe to Ancel Glink's Quorum Forum podcast and leave us a review wherever podcasts are heard. We prefer good reviews. Send us your questions and show ideas to podcast@ancelglink.com, and you can visit us online at quorumforum.ancelglink.com. Can I get a motion to adjourn? Can I get a second? Second. All in favor? The ayes have it. We'll see you next time at Ancel Glink's Quorum Forum podcast. Bye. Bye.